Hi, I'm Ann K. Wood. I get to be the director of Lowcountry Legal Volunteers. I am here with Cherished Handy today, who is a wonderful local attorney. We're going to be speaking about certain things related to wills and heirs property information that is vital for the entire community to know about. I want to tell you a little bit about Lowcountry Legal Volunteers though first. I get to be the director. We have a wonderful team there, and Cherished is going to be a part of that team now, assisting us with folks that need wills and heirs property information. We also do family law. We get folks child support. We get domestic violence restraining orders for folks. We also do simple wills and healthcare powers of attorney, which we're going to speak about some of those wills and services that we can provide to hopefully prevent heirs property issues. We also do housing protection, which would include eviction defense and unsafe housing actions. So all the basics of the law we're able to provide for free due to generous donors and grantors, and we provide those services to folks that are living at or below 200% of the federal poverty guidelines. So to get more information on us, all you have to do is check out our Facebook or social media, or more importantly, go to lowcountrylegalvolunteers.org, where you can find out more about legal volunteers, and you can also apply for services in Spanish or English 24/7. So with that, I would love to introduce my partner in crime today, Ms. Cherished Handy, and you'll share a little bit about yourself.
Thank you, Anne, for that wonderful introduction. I am Cherished Handy. I am a local attorney, and I am the owner of the Heritage Law Firm. My practice focuses on heir property issues, as well as other title issues, probate administration, and real estate closings. We also do estate planning, such as simple trust, family LLCs. In general, my firm is focused on preserving family property and making sure that the owners have the correct title or the proper protection to sustain their property to create generational wealth.
And with that, we'll get started. We really want to share some important information with you today about heirs property, otherwise known as family land, sometimes known as tangled title issues. What that is, first and foremost, but also how you can prevent it. And so we'll just kind of get started on that. And I'll kind of turn it over to my expert to my right here, Ms. Handy, if you want to share.
Of course. First, we will get into what is actually heirs property. And I know the term can be confusing and deceptive, but heirs property in this context is property that's owned by multiple owners that we would sometimes refer to as tenants in common or co-tenants. And the multiple owners could be 3 individuals or over 100. The problem with heirs property is that no one can discern legally who the heirs are, meaning who the owners of the property are and their ownership interests. That being said, with such a tangled title, it's difficult to use the property as a normal property owner would. For example, having your property passed to your descendants the way you intended, selling your property, refinancing your property, using it as collateral, obtaining government subsidies to benefit the property. So heirs property is a vulnerable state, which means that it could be easily taken away. Taken away means sold. I don't want to get too far down with heirs property. I can speak on this topic forever. But what we want to focus on is how to prevent heirs property. And as Anne mentioned, one of the ways and the purpose of this initiative is wills. Wills to direct how you want your property to pass to your descendants, not how the state of South Carolina determined. Without a will, state of South Carolina will determine how your property would pass at your death.
Yeah, and I thought it was interesting because we've had many conversations when we're getting ready to do this important work together as a team. But Cherished, you had shared with me that people think heirs property sometimes is a good thing. And we want to kind of bust that myth. And so if you want to share.
Oh, absolutely. And I think the best way to explain that is by example. So under South Carolina law, any co-tenant or heir to the property has the right to possess the property, have the right to access the property, and most importantly, has the right to partition the property. And let's speak to the most detrimental first, partition. For example, if there's heirs property and you have what the community would term as the main heir, which is no such a thing, living on the property, and let's say the individual was living on the property for 20 plus years, paying the taxes, maintaining the property. However, because it's heirs property, there are other owners to the property who do not live on the property. They may not even live in this state. However, because they have an interest, and if the property cannot be subdivided fairly, that heir could petition the court, have the property sold. The sales proceeds would be distributed to each heir according to their ownership interest, and that heir who's been living on the property for 20 plus years would be displaced. They would have to move, of course, because a new owner would own the property. That's one of the most vulnerable aspects, in my opinion, of owning heirs property. Secondly, it doesn't matter how long an heir was living on the property in most circumstances. If there's another heir who has an interest, that heir has access to that property, regardless of if the structure is a mobile home or if it's a state-built house. That heir has access to that property, any heir. So in order to prevent that, we need something in writing, because all agreements that affect real estate must be in writing, to determine who owns the property, meaning who has access to the property, who pays the taxes to the property, which brings us to another aspect of heirs property, taxes. Who's responsible for paying the taxes? The heir who's living on the property or any heir that owns an interest? Well, according to South Carolina law, any heir or any co-tenant to the property has the legal obligation to maintain and upkeep the property. Paying the taxes preserves and upkeeps the property. Each heir has that legal duty. So just because one heir is living on the property and paying the taxes does not mean they own the property to the exclusion of the other heirs. And just because the other heirs does not contribute to the taxes, does that mean that they does not have an interest in the property and cannot access the property?
Exactly. So I think that's like such a good point, Cherise. I mean, one of the things, we go and speak to a lot of community groups with legal volunteers, and Cherise is going to be a big part of that given her expertise going forward. But one of the things, I got asked a question, Cherise, by a gentleman who was a reverend, community leader, super smart guy, but he said, do I only need to pay the portion of the taxes on the amount of the property that I own? So I'll let you answer that, I'm sure, very handily.
Well, here's another misconception about heirs property. The property is not sectioned off, meaning that if several heirs live on the property or if only one heir live on the property, you don't have a specific portion of that property that's allocated to yourself. By default, according to South Carolina law, each heir has an undivided interest in the whole. That means if there is a parcel that is 50 acres and you have several heirs, let's say one heir owns 10%. That doesn't mean that they own a portion of the 50 acre property, 10% of it. They do not own 5 acres. They own 10% in the entire property. So when you pay taxes on the entire property, the entire amount. The county will not accept partial payments. That's another thing. So if someone is attempting to pay taxes on a portion that they feel erroneously that they own, first of all, the county will not accept it. And the entire tax amount would have to be paid, which is why, again, it is important to have some agreement in writing to discern who is to pay the taxes, who's going to be responsible for maintaining the property, and most of the time you can do that by will.
So wills are important. We are going to get into that. There's one more aspect that I wanted to ask Cherise about specifically so folks would know. So Cherise, you know, everybody and anybody who's an heir to this property has the right and the responsibility to pay the taxes on this family land, this heir's property. Yes. What if no one pays? What happens when no one pays the taxes?
When no one pays the taxes, your family property will be sold at tax sale, period. And no one heir is responsible, yet every heir is responsible, meaning that every heir is responsible for paying their proportionate share of the taxes. For example, if you own a 10% interest in heir's property, legally, you are obligated to pay 10% of the property taxes. And unfortunately, it was one time in this county, Beaufort County, I am unsure about the surrounding counties, that investors or public who attend tax sales, they would give heirs property courtesy, meaning that they won't bid on heirs property to give the heirs a chance to maintain the property or to redeem the property from tax sale. That does not happen anymore. Investors and attendees of a tax sale are not obligated to not bid on heirs property. And we are all aware about the value of property in Beaufort County and surrounding properties and investors, and, you know, face it, South Carolina is, people want to move to Beaufort and the surrounding counties. So with that said, with most heirs property, with the heirs being, let's say, property rich and cash poor, if you will, it's very difficult to outbid an investor at a tax sale. So I say that to say, if the taxes aren't paid by someone in full, the property will be sold at tax sale and the family property would be lost.
Yeah. And that's devastating. Obviously, it goes without saying how devastating that is to local families that have been here for so many years. So one of the resources that we want to speak about today is what if you can't afford the taxes on your property. One of our community partners, the Lowcountry Legal Foundation, who was founded by Luana Graves Sellers, she will assist folks. She has a foundation to assist folks that cannot pay their taxes. There are certain requirements on that, but she is a great resource. So we'll be speaking about different free resources for folks to access so that they can save their family land.
It's absolutely. And I would also like to add, once family land is saved, that should be some indication that something needs to take place to prevent this from occurring in the future. And with heirs property, the most stable form, in my opinion, once the title is cleared by a quiet title action, something more should be done. Because if you go through the time and expense to clear a title, and then someone dies without a probated will, then you have the same problem again. So after the title is cleared and we discern who the legal heirs to the property are and their ownership interest, the property should be put into some type of estate planning device to prevent it from becoming heirs property again. And that could be a family trust or a family LLC or a co-tenant agreement. And that would say, we are the heirs of this property. This individual or individuals are responsible for these items, and whatever the heirs decide. The caveat is all heirs to the property has to agree. So in general, once the heirs property is straightened or quieted, something should be done to prevent the process or the title from being tied up in heirs property, if you will, in the future.
And I think one thing that I want to speak about so people know all of the resources, one of our partners is the Center for Heirs Property. They will assist folks with clearing title, and local private practice attorneys do that, such as Cherise Handy and others in the area. But if you qualify for Center for Heirs Property, they will assist you and help you get to the finish line of clearing the title to your family land. But that is something that needs done. If you quiet the title, clear the title, everything's all hunky-dory, so to speak, and you don't put the property into a trust or into an LLC or something else that's gonna safeguard that property going forward, and one heir dies without a will, what happens, Cherise? What's the next thing that happens?
You have heirs property again. And again, heirs property is property where someone who has an ownership interest in the property dies and the property is passed through operation of law. However, there is no legal document, there's nothing in writing to discern who those heirs are. So if you have 10 owners and the property was quieted or cleared in the name of those 10 owners, the 10% interest each, and one owner dies, let's say a week after the property was quieted, then you have heirs property again, because no one would be able to discern who the heirs of that one person is without a probated will or some other estate planning device. So again, once title is cleared, we have to put that property in what I would call some legal container, if you will, to preserve it.
That's some good imagery. Yeah, I would totally wholeheartedly 100% back that up. Everybody needs a will. We have clients come in all the time for different services. Anybody over the age of 18 needs a will. They also need a healthcare power of attorney, which is something we're going to offer at various community clinics throughout our service area, which is Beaufort, Jasper, and Hampton counties. But speaking on wills in general, what are some of the benefits of actually having a will? We've spoken about one big one, preserving family land, but what is another, or a few?
Okay, well, first of all, I want to address making a will is not the end-all be-all. The will has to be probated. If you make a will and if your descendants does not probate the will, it is as if you died without a will, okay? So a will must be probated. Secondly, it must be probated within 10 years of death. If the will is not probated within 10 years, it is just as you died without a will. And benefits of a will, so many. You would dictate who your heirs are in regards to your property, meaning that you will be able to tell the courts or the state of South Carolina, hey, when I die, I want my property to pass to these individuals. Otherwise, South Carolina decides by our intestate laws. A will also can speak to a trust. You can have a trust in your will. We won't go there at this time, but a will is any document that passes title upon death. So you can be really creative. You could have guardianship issues in a will, conservatorship in a will. Some people even direct funeral. Funerals in their will. And the will prevent your family or your heirs from going through the expensive, time-consuming, arduous process of clearing title. So it gives your family members a peace of mind. You can also pass personal property in a will. It's not all about real estate. Personal property, cars, especially vehicles where no one likes going to the DMV. A will would make that much easier, an easier process. And
Yeah. So, I mean, there are 1,000 different benefits to having a will. And like I said, we love to provide folks with simple wills to prevent heirs property issues, but also to give that individual person the freedom to state what they want to happen after they pass. And I think Cherise had touched on this. You know, we have clients that are young mothers, young fathers, and they want to state who has guardianship over their children should they pass. And one thing Cherise had mentioned, you know, say you have some personal possessions like jewelry or something you want to make sure are passed down in a certain way. That's another advantage. It really is about personal choice and personal freedom. So it's a wonderful thing to have a will. If you're 18 or older, you should have a will, period. End of story. So I guess that leads me to the question of, you know, intestate. You had mentioned intestate. Somebody passes away without a will, and then the state of South Carolina is in charge of all your stuff. What happens then typically?
typically, when there's intestate succession, we have what no one wants, which we call sometimes a laughing heir. Okay, and a laughing heir is someone who has absolutely no relation to the owner of the property, to the deceased owner of the property, but they somehow, because of South Carolina intestacy laws, inherit a portion of, or sometimes the entire property. And I will give you an example. According to South Carolina law, if you die and you have a spouse and children, your spouse would get half and your children would share half, okay? And let's say you die and you left a surviving spouse who owns 50%, and your children, you have 2 children, each own 25%, okay? And then your spouse remarries, and then your spouse dies without a will. What happens? The spouse new wife would get 50%, which is 25%, and your children would share the other 25% of their father. So now you have your spouse's surviving spouse sharing title to property that you own. You want to prevent that by telling South Carolina.
That's not enough to get you to do a will. I don't know what is, Cherise. That is well said. Yes, especially with blended families as well. Absolutely.
Yes, and adoptions.
Yes.
So South Carolina dictates who the property is divided to if you won't.
Yeah, absolutely. Yeah, so is there anything more that you feel is important to know on wills or the importance of having a will, so people know about that?
Yes, well, responsibilities and duties. I know there's a common misconception I know in this community with heirs property that the oldest heir is in charge, or the heir that's living on the property is responsible for paying the taxes, or if someone gives a directive by word of mouth, like your grandfather says, hey, I want you in charge of this property. The law does not recognize that. When you have a will, you will have a personal representative or an executor, and that personal representative have the duty while your estate is being probated to pay the taxes, upkeep the property, so that the personal representative can release the property to your devisees or heirs in your will. That's a clear cut that the personal representative would pay the taxes. there would be no ifs, ands, or buts about it. However, without a will, if you die, who is responsible for paying the taxes? What if, your heirs like, well, my older sibling will pay, and your older sibling is thinking, oh, my younger siblings will pay, and no one pays the taxes, and it goes up for tax sale.
Yes.
So a will can also delegate duties to preserving the property.
Yeah. And I think one of the hardest things is when a loved one passes away, if there's confusion, if there's division, a lot of times having a will save your loved ones lots of pain and agony and potentially, total family division. And I know we've seen it, and I know in your practice you've probably seen it. So having documentation of what you want before you pass on really helps generations of your family potentially going forward. Anything else you want to share on wills?
Oh, yes.
Okay.
When, not if, when you create a will, you must tell someone where the will is located. Because if you create a will and no one is able to locate the will, the law will treat it as if you died without a will. So I know, individuals want to be secretive sometimes, depending on the family relationship, but it is very important to let someone, and I would recommend your executor or personal representative named in the will, where your will is located.
And I was just going to ask really quick, Cherise, what are the benefits of actually having a South Carolina attorney, whether it's a free legal resource like us or a private practice attorney, a South Carolina attorney, do your will? Say you move from out of state. What are the benefits and what are the risks of not doing that?
Well, states have different laws, different intestacies laws, and you may have property in different states. And you can include all of those properties in one will, but you want a South Carolina attorney who is well versed with South Carolina intestacies laws, and I would say the ramifications of owning heirs property, because wording is very important. Words are important, and you want your intent to be clear to the personal representative who is probating your will, and you want your provisions in your will to be so clear as to eliminate confusion, which could make the estate process even longer and more expensive. And it's a good practice to have a South Carolina attorney create the South Carolina will for property that's located in South Carolina.
Yeah, and that's something we want folks to know about, not only private practice attorneys who are wonderful, but say you might be of lower income and you still need a will. So we are constantly having wills clinics. We're doing outreach on heirs property, education together. So the way to just check out our website at lowcountrylegalvolunteers.org is the way to find out what's going on, or on our social media is, updated quite frequently as far as what the free wills clinics. So another thing I want to talk about, Cherise, is healthcare powers of attorney. So the free legal services we provide include not only the simple wills that are so important, as we've just discussed, but also healthcare powers of attorney. So essentially, healthcare powers of attorney are just that. You're designating an agent to make healthcare decisions for you. So, if you are incapacitated, say you got in a car wreck, then you've got someone in place that's able to and authorized to make important medical decisions for you. And you can share with them what's important to you. Do you want to donate an organ? Do you want to not donate an organ? Do you want to, have prolonged life-saving treatment or not? And I think one of the things that Cherise and I have discussed is, it's important for your loved ones, anyone over 18, even if that's your child, you're not going to have the legal authority to make those decisions for them once they are of age and adults, unless they designate you. So I don't know if you want to speak a little bit about the importance of having that document.
Oh, absolutely. In order for your agent and your healthcare power of attorney to make decisions based on your behalf, they would have to have medical information. Ordinarily, HIPAA laws will prevent that. So a healthcare power of attorney will actually circumvent, some of the HIPAA laws so that the medical provider can candidly inform your agent of your health condition. Also, in tragic times of where there's a decision to be made on whether to sustain life artificially, if your wishes and your desires are in writing, it takes the burden from your loved one from making that decision, because it would be clear what you would have done in that situation if you could have made that decision. So it would relieve the burden from your loved one to decide whether they should maintain artificial life-sustaining abilities, organ donation. So
a lot of tough decisions.
Absolutely, yes.
Yeah. And I think we all know this as just people. We know that healthcare crises don't happen, on a schedule. You're in the middle of it, you're in chaos, you're trying to help your loved one, you're trying to be an advocate for your loved one in that moment, which is not on any timetable. So already having that in a calm setting, you've made the decision, you've notified your agent or your alternate agent that you want them to make these decisions and have a conversation. Here's what's important to me, so there's not guesswork when you're in that moment of the 11th hour and, everybody's in a crisis. So that's one thing, so people have that comfort to know how to care for you. And even if you're just going for an outpatient surgery, you still want to have that in place for your loved ones in case they need to make a decision at that moment for you.
Absolutely. And we know how family discourse can arise when there is an agreement as to how to proceed, with your loved one's healthcare future, so to speak.
Yeah,
so
absolutely.
That would eliminate those.
Yeah. So I do want to thank the Freedman Arts District for partnering with us and giving Cherise and me and legal volunteers the opportunity to speak about these vital and important issues. One of the things I don't want to miss sharing with you is that there are wonderful resources out there, whether you're lower income or higher income, what have you. But for folks that happen to be lower income, some free legal resources, of course, is Lowcountry Legal Volunteers. We serve Beaufort, Jasper, and Hampton counties. And so we also partner with SC Legal Services. They also provide free legal services, including wills. The Center for Heirs Property is wonderful. They provide clearing of titles, other types of services, but they also do wills clinics and heirs property education. So those are some vital resources. But some other resources that we may not have mentioned already would be going to the courthouse, going to the probate court, finding out more information, going to the Register of Deeds. Some of these things you can do on your own. And I don't want to miss talking about the Heritage Library that is based in Hilton Head, but they've done so much title work going back pre-Civil War that as an heir, you're going to need that information. And I don't know if you want to speak on that a bit, because I know you're an expert in that world too, Cherise.
I think, well, sometimes, we all don't know our genealogy. And those public records, the census, the information at the Heritage Library could actually help, for example, how many members was in a particular household at a particular time, who they were, what the relations. So it really helps with creating a family tree to actually discern who the heirs are to a certain property or certain individual and what percentage ownership they would have as an heir. So yeah, it's a very, very helpful, valuable resource, the Heritage Library.
And here in Beaufort proper, we have an office located at 80 Ladies Island Drive, right by St. Peter's Catholic Church. We actually share space with not only the Lowcountry Gullah Foundation, but also the Heritage Library. So they have their main space on Hilton Head Island, but they have a wonderful space where they can have meetings and help families right here in Beaufort. So that's a wonderful option for folks. And I want to make sure I don't miss any other resources, but I think, have I missed any of the other free resources, Cherise? I want to make sure everybody knows.
I think you touched them all.
Yeah, and we're getting ready to do hundreds of wills together throughout our service area. So we're very excited to do that. We can't wait.
Wills. Yes.
Wills all day long. And so if you do have questions or need to apply for services, again, just go to the website, lowcountrylegalvolunteers.org, or you can call us at 843-815-1570. Again, we're so excited for this class, but also our new partnership with the Freedman Arts District, because they are doing so much important work, and we're glad to partner up with them to really make a difference in people's lives. For generations, we hope. That's the goal. But I don't want to lose any myth-busting opportunity, and I know that Cherise doesn't either, about heirs property issues. So I think we're just going to let you talk about that a bit.
Thank you. I would like to dispel some myth that I have come across in my practice that turns out to be detrimental to property ownership, and some of those are that physically living on the property gives you more right than the other heirs, and I touched on that earlier. If you are living on heirs property, it does not give you exclusive ownership against the other heirs to the property. They have the same rights to possess the property and to access the property. They can also sell their interest in the property to a third party. So a common myth is that if you live on the property for many, 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 many years and you pay the taxes, it does not exclude the other heirs from having the legal rights that comes along with property ownership to that property. Secondly, and along with that, paying the taxes on the property does not give you more rights than the other heirs. You have a right against the other heirs to sue them for their proportionate share of the taxes, and that's called an action for contribution, but it doesn't give you ownership, and it doesn't give you more rights other than the right to recoup your share of the other heir's share of the taxes from the remaining heirs. All heirs to heirs property does not have equal ownership interest. It depends on generation, and it depends on how much interest your ancestor had in the property before they passed away, and of course, South Carolina intestacy law. So just because there are numerous heirs to the property, they all do not share an equal ownership interest to the property. A land survey does not convey ownership, meaning if you pay a surveyor to survey heirs property, that does not mean you own the heirs property. Again, you may have an action for contribution so that the other heirs could contribute to their proportionate share of the survey costs if the survey benefits the heirs as a whole. Other than that, a survey does not give you title to heirs property. Verbal agreements concerning heirs property, such as, when I die, I want you to be in charge of the property. When I die, I want you to divide the property among your siblings. It does not have any legal effect whatsoever. Any agreement that deals with real estate, any legally binding agreement that deals with real estate has to be in writing and signed by all parties or the parties involved. And again, that takes us to no one is in charge, or quotes, of heirs property without a written agreement. And again, I know that we most times revere the oldest child or oldest sibling. That does not give them any more rights than the younger family members. And finally, powers of attorney ceases or stops at death or divorce. So if your ancestor who you inherit property from gave you a power of attorney while they're alive, once they die, that power of attorney has no legal effect at all. It stops. And if there's a divorce between spouses and there's a power of attorney, then that divorce stops the power of attorney.
Cherise, this has been a serious discussion, but I just appreciate your expertise so much. I'm glad you're joining Legal Volunteers
Absolutely.
to help
It's my
get
pleasure.
folks some wills and heirs property information. So I think that the big question is, we want to make it simple. If you need a will, call Lowcountry Legal Volunteers or SC Legal Services, and you can get a free will or Center for Heirs Property. Those are resources. If you have tangled title of your family property, call either a private practice attorney, or if you qualify, call Center for Heirs Property. They do come down here locally. They are in Charleston, but they do come down to our service area, and we are partnered with them. Say you can't pay your taxes, who do you call then? You're going to call Lowcountry Legal Foundation if you are in Beaufort County. That's an excellent resource. We're just so happy and honored to be able to share information with you. And we know that this information will be shared via the Freedman Arts District for years to come. So we're excited about that. And if you need us, please call us. Thank you.
Thank you.